Thank you, Gary, for sticking to your time limits. That's good. We will have the questions after the 3 presentations, and so keep them in mind if you have some for Gary. Our second speaker is Andrew J. Cecchinato, from Trento. Andrew is in Italian and attending a second year of doctoral school in comparative and European legal studies in Trento. There he graduated with a dissertation on legal education of Thomas Jefferson, and that's why he will talk about Thomas Jefferson constitutionalism. We are curious.
Thank you very much. Allow me to begin by thanking the organizing committee for their warm welcome. You've been outstanding, and thank you for being here this afternoon and allowing me to share some thoughts on the research I am currently engaged in. As was mentioned, the title of my presentation this afternoon will be Between Transience and Perpetuity, the Living Generation as Usufructuary of Popular Sovereignty in Thomas Jefferson's Constitutionalism, and this will be a threefold presentation. I will begin by illustrating Jefferson's understanding of the transient nature of human law, whereby human law I intend, following Jefferson, both municipal law, statutory law, and constitutional law. And I will highlight how this conception lies at the basis of Jefferson's advocacy for frequent constitutional change. This, in turn, reflects in his conception of sovereignty and the distinction he draws between abstract entitlement and substantial exercise of sovereign power, which he conceives as a kind of usufruct, the topic of the second part of my presentation. And then, after having briefly sketched a history of the relationship between usufruct and the notion of sovereignty and its exercise, I will try and suggest a possible genealogy to Jefferson's doctrine by closely reading in comparison one of Jefferson's key texts, a letter he writes to James Madison on the 6th of September 1789, with 2 chapters of Baudin's Six Livres de la République, chapter 8 and 9 of the first book. So let's begin. In the closing paragraph of the bill establishing religious freedom, drafted between 1776 and 1779, Thomas Jefferson pitted the transience of human laws against the perpetuity of natural rights. Whereas an assembly, and I am quoting, elected by the people for the ordinary purposes of legislation, cannot restrain the acts of succeeding assemblies, unquote, natural rights outlast the municipal laws enacting them. Far from being perpetual, municipal laws remained in force for as long as the legislature who enacted them retained the right to exercise, and I quote again, the sovereign powers of legislation, unquote. Hence, Jefferson believed that municipal laws extinguished with the passing of those who had given them force, and argued that each successive generation possessed the right to reconstitute anew the laws by which it lived. This doctrine, according to which each generation possessed the inherent right to exercise for itself the sovereign powers of legislation, furnished the basis of Jefferson's advocacy for frequent constitutional change. The need to regularly revise the fundamental compact, which animated Jefferson's occasional and sometimes violent antagonism towards the Constitution, and particularly against those who, in his own words, look at constitutions with sanctimonious reverence and deem them, like the Ark of the Covenant, too sacred to be touched, was motivated, according to Hannah Arendt, by Jefferson's intuition that popular sovereignty needed to be perpetually exercised in order not to be lost. The fear that despite their proclamation of popular sovereignty, the founders might have denied their successors the freedom to establish their own laws and devise a form of government suited to their own needs by establishing a permanent constitution, led Jefferson to distinguish between the abstract entitlement of sovereignty, belonging to the people, and the substantial exercise of its prerogatives. These belonged to each generation separately. Through their agency alone could the people, quote, choose for themselves the form of government they believed most promotive of their own happiness, unquote. Therefore, Jefferson argued that all institutions established and all obligations contracted by one generation during the span of its lifetime expired as that generation died away and a new generation succeeded it, acquiring in turn the right to govern itself free from any previous burden. This distinction between the wielder of sovereignty and its holder that Jefferson drew in a number of writings, most prominently in the letter he addressed to James Madison I mentioned earlier, which was written in Paris when Jefferson was ambassador of the United States to the Kingdom of France. This distinction, as I was mentioning, between the wielder of sovereignty and its holder has a long history of its own that revolves around the notion of usufruct and reverberates in the words through which Jefferson phrased his understanding of popular sovereignty. This history begins at the time of the Jus Commune. Medieval jurists had found in the Corpus Juris a text which in their eyes expressly indicated in the will of the people the source of rulership. Ever since the days of the glossators, the 12th century, the universally accepted doctrine was that an act of alienation performed by the people in the lex regia had transferred the ultimate power from the populus to the princeps. The legal nature of this translatio, however, was hotly debated. According to a first interpretation, there had been a definitive alienation, whereby the people had renounced their power for good, subjecting themselves to the imperium of the prince. On the other hand, a second interpretation saw the translatio as a mere concessio, whereby the people had granted to the prince simply the use of their supreme power and remained entitled to resume it when conditions arised. This concessio was regarded as a kind of usufruct, which established a bilateral relationship between the wielder of sovereignty and its holder, and allowed medieval jurists to maintain that sovereignty remained in the people despite the institution of a monarch. This second interpretation, the one that reads the translatio as a kind of concessio of the use of sovereign prerogatives, proved to be highly influential. Otto von Gerge has in fact argued that the theory of popular sovereignty built by lawyers such as Cinus Pistoriensis and Paulus Castrensis upon the notion of usufruct, influenced through the later mediation of Hotman, Duplessis Mornay, and other monarchomacs, the French jurists of the 16th century, who opposed the absolutist theories of someone like Bodin, influenced the doctrines of Althusius and Grotius, just to mention two later scholars. And it is further possible that this same interpretation ultimately reached Jefferson himself, leaving a trace of its memory in his constitutional doctrine. I say it is possible because one of the problems scholars of Jefferson face is that Jefferson hardly ever quotes any of his sources. And so reconstructing the genealogy of a principle requires to find some other pathways that don't begin with a direct citation. To illustrate how, although sovereignty belonged to the people, it was each successive generation who wielded independently its prerogatives, Jefferson famously claimed that the earth belonged in usufruct to the living. So there is, in my view, at first a recollection of a previous tradition in Jefferson's writing. And in so doing, he seems to have perhaps understood sovereignty in keeping with the interpreted legacy of the lex regia. By recalling the notion of usufruct, Jefferson implied that the living generation embodied pro tempore the will of the people, and could therefore only manage, the word is his, the rights and powers necessary to rule over the corporal globe and everything upon it. Also, this was a citation. Manage and not dispose at will, for the rights exercised by the living generation insisted upon ares, the earth, it did not own, so as broad as it might have been, its power was intrinsically limited. What Jefferson, I think, is attempting to do is build a super-constitutional limitation on the exercise of sovereign power. Once he recognizes that constitutions as laws are transient, he still feels the need to find some kind of limitation and seeks this need in the natural law institution of usufruct. By limiting the power of each living generation to dispose of the earth and all it encompasses, Jefferson is at the same time guaranteeing to succeeding generations the right to exercise the same power, preventing the risk that the living generation might end up consuming all that is at its disposal. Having briefly sketched the outline of Jefferson doctrine, I would now like to try and read this doctrine in comparison with Bodin and the statements he makes in the 8th and 9th chapter of the first book of his République. Why have I turned to Bodin? Because Jefferson not only owns Bodin, but he has marked the copy of the République These markings are not marginal notations, but they are marginal hyphens highlighting select passages. There is some debate over the authorship of these markings. For the purposes of my presentation, I will assume they're his. If you are curious, we can discuss about the authorship later on. Nevertheless, I will mention that even if these markings should not be his, there are arguments to suggest that Jefferson not only read, but might have been influenced by Baudin. Of all the markings in the République, the most striking may be found in the 9th chapter of the first book. It is a very small, unobtrusive marking on page 182, made by only 2 vertical dashes, highlighting the following passage. Car les princes souverains, à bien parler, ne sont qu'usufructuaires, ou pour mieux dire, usagères du bien et domaine public. Should one choose to read the markings inscribed in the République in relation to Jefferson's constitutional thought, it would become very hard not to wonder whether Jefferson had in mind this very passage while writing to Madison, "The earth belongs in usufruct to the living." The pairing of usufruct and sovereignty is such a topical staple of Jeffersonian constitutionalism that many interpreters have believed it to be an entirely original conceit, and have construed it in light of Jefferson's biography rather than his legal education. Jefferson was personally very much concerned by his own financial indebtedness, and in the letter he writes to Madison, one of his preoccupations is that the living generation may incur in debts so great that it would impair the sovereignty of subsequent generation. Although personal experiences may undoubtedly have shaped Jefferson's understanding of constitutional issues, the question, and I am quoting, whether one generation of man has the right to bind another, unquote, that Jefferson raises in his letter to Madison is essentially a legal one and should be treated as such. Should it be read otherwise, it would become very difficult to understand how Jefferson could have placed it, and I'm quoting again, among the fundamental principles of every government. Jefferson frames his analysis as an exercise in comparative legal history. By acknowledging that the question he raised has never been answered either on this side or on that side of the water, he invited Madison to pit the forthcoming observations against previous American and European scholarship. The whole central portion of the letter is in fact a comparison between the principles governing the succession of French kings and the principles devised by Jefferson to govern the succession of subsequent generations of a sovereign people. It is therefore in this specific context that Jefferson's reflections should be read, for it is in relation to the doctrine of succession that they were written. Previous authors had indeed wondered whether one sovereign king could rightfully bind his successor, but as Jefferson noted, no one had yet asked whether a sovereign people could bind generations to follow. Hence Jefferson sought to ascertain whether the principles governing successions of kings could be applied to succession of subsequent generations of a sovereign people. And he further inquired whether the limitations constraining rulers from undermining the sovereignty bequeathed to their successors equally restrained the living generation from burdening following ones with debt and other constraints that would have ultimately impaired their claim to sovereignty. It is by virtue of these limitations that Jefferson argued each generation held the earth in usufruct rather than in property, and it is by virtue of these same limitations that Baudin had earlier claimed that no prince could rightfully aliéner les domaines et les droits de souveraineté, car les princes souverains, à bien parler, ne sont qu'usufructuaires. The analogy between these two arguments is further heightened by the exemplum referred by Baudin to illustrate the aforementioned principle. Baudin quotes an instance in which the Emperor Charles IV confirms privileges granted to the city of Perugia, but he confirms these principles upon condition that they will remain in force for as long as he lives. Once he dies, they will expire. Precisely because the prince held in usufruct to the kingdom and was not allowed to impair his successor's sovereignty, Charles IV confirmed the privileges granted to the citizens of Perugia only for as long as he lived. In other words, the kingdom belonged in usufruct to the prince exclusively for the span of his lifetime. And consequently, once a new king was coronated, all the estates and the corporations of the kingdom had to request confirmation of their privileges. This earlier remark, which can be found in chapter 8 of the same book of the République, is equally highlighted by vertical dashes and conclude a long passage dedicated to Baudin to laws and their coming into force. Here Baudin remarks once again that laws remained in effect only throughout the life of the prince who enacted them. And I raise a question at this point. Isn't this, mutatis mutandis, Jefferson's same argument? Isn't this claim that laws expire with the passing of each generation and new generations are entitled, I beg your pardon, isn't this claim that laws expire with the passing of each generation and new generations are entitled to enact their own laws and even more so to reconstitute the Commonwealth strongly reminiscent of Baudin's highlighted remarks in the République, according to which all communities must seek confirmation of their privileges upon the succession of a new prince, for privileges and laws remain enforced exclusively for the lifetime of the prince who enacted them? I think that at least tentatively the answer might be affirmative. After all, Jefferson himself acknowledged in the letter to Madison that this principle that the earth belongs in usufruct to the living and not to the dead, quote, is a very extensive application and consequence in every country, most especially in France, unquote. But what would the theoretical justification be? How could Jefferson, and for that matter Baudin, maintain that sovereigns were free from the laws enacted by their predecessors? This question points directly to the heart of Baudin's doctrine. The prince is sovereign insomuch as his legislative power is absolute, i.e. unconstrained by positive municipal law, whether it be enacted by him or by his predecessors. His only constraints are dictated by natural and divine law and by the fundamental laws of the kingdom. And this is remarkably the exact same argument laid down by Jefferson in his letter to Madison, quote, between society and society, or generation and generation, there is no municipal obligation, no umpire but the law of nature, unquote. Sovereigns, whether they may be individual princes or a collective people embodied in one particular generation, wield a power unrestrained by civil law and checked exclusively by natural rights. It would thus appear, regardless of whether the markings in the République were actually inscribed by Jefferson or not, that Jefferson's constitutional thought was strongly influenced by Baudin, and clearly his principle, according to which the earth belongs in usufruct to the living, was conceived in an attempt to reshape one of the staples of continental jurisprudence to conceptually secure the United States' claim to sovereignty, while at the same time addressing the fundamental problem of Jefferson's mature constitutionalism, how to guarantee to each and every citizen and each and every generation of a sovereign people the full participation in, quote, the government of affairs, unquote. In this sense, Jefferson's constitutionalism may deserve further scrutiny, for it seems to have mainly concerned itself with what Harold Lasky has called, quote, the most real problem of modern politics, unquote, not just a proclamation of popular sovereignty, but the substantial attainment of its substantial attainment and exercise. Thank you.